Hello, everyone. This is Attorney Lou from New York. Today, I'll be talking about what you need to know before you send out an attorney demand letter. Last time, we talked about what to do when you get an attorney demand letter, right? So today, we'll be talking about the other side of it. You're the one who wants to send one. Someone may owe you money, someone may infringe upon your trademark, someone may breach a contract with you. You go to a lawyer, and first sentence you utter to him, maybe just send him a demand letter and see how he reacts, or maybe this may scare him into good behavior. Behind that sentence is assumption you have made that the letter itself carries some kind of binding legal force. Let me analyze this for you, okay? First, that letter sent from your lawyer does not really have truly legally binding force, usually not. It is just a letter. It's not a subpoena, injunction, or judgment. The recipient has no obligation to reply or comply. If you expect that attorney demand letter will have some kind of magical power to turn somebody into compliance, you need some amount of good luck for that to happen. But an attorney demand letter will achieve something, okay? It will make an intelligent opponent to evaluate his legal option, to see whether he should try to negotiate with you or maybe he has concluded that you will not have the willpower and legal fee budget to fight him, so he may well ignore it. But there are a few things that, assuming he does not ignore it, that your attorney demand letter may accomplish. First, whether he ignores it or not, right? It gives you the other side the formal notice, putting the other side on a notice of the dispute. For example, if it's an intellectual property case that bears directly on willfulness, by sending the letter to your opponent, you have put him on notice that you are taking a legal position that they are intentionally infringing upon your right on the date, at least, that you send a letter to them, right? So you may fix a date later on if you prevail in the underlying legal action. That may entitle you to triple damage, right? You may also set a neat date to start the calculation of interest accruing upon any kind of judgment you may subsequently obtain. It may also trigger the other side to report this letter to his insurance carrier, because most liability policies will require the policyholder to notice the insurance company of the claim, and the insurance carriers may be more ready, willing, and able to be engaged in substantive discussion, whether it's settlement or pre-litigation exchange. It puts an informal dispute onto a written record. A messy email and back and forth now has been distilled into hopefully a concise but accurate attorney demand letter, setting forth the relevant facts and timeline of events. And how the recipient responds or does not respond, could become evidence in the subsequent lawsuit. And here's the big end, the overlooked one. It puts the duty on the other side to preserve the evidence. Under American law, the moment a party reasonably anticipates litigation, the duty arises immediately for it to preserve the evidence. And your demand letter kind of formalistically trigger that kind of obligation on the part of your opponent. From delivery, they can no longer argue that they did not know, that you will never sue them. You never intend to sue them, right? If they delete relevant evidence anyway after you send them the demand letter. Federal Rule of Civil Procedure 37E may empower the court to order the other side to retrieve the evidence, from backup tapes and all that, and bear all these expenses, right? And it may even instruct the jury to presume the destroyed or compromised evidence was unfavorable to your opponent, and may even bar your opponent to provide any kind of defense on that issue that may potentially be covered by the destroyed or damaged or tampered evidence. Or a judge may go that far to just go straight into the entire underlying case and rule against the party that has knowingly destroyed or tampered with evidence. Meaning the judge will not really allow the jury to go through all the facts and will just, as a matter of law, rule against the party that destroyed or tampered with the evidence. So the most boring paragraph in a well-drafted demand letter, the litigation hook, that's the terminology, is often the most valuable part of a demand letter. Sometimes that may be the entire reason that your lawyer sent the demand letter. Third, you need to think about the pragmatic aspect of American lawsuit, meaning legal fee. American litigation follows the American rule that unless contract or statute or court orders otherwise, even the winning side of a litigation pays its own legal fee. This makes litigation rather expensive for both sides. So when your opponent decides whether to, concede to you, it is not only that he was evaluating the strength or merit of your claim. He's asking three questions. Will you actually sue him? How much legal fee and time you have to spend to sue him? And will both sides be better off settle now rather than, fighting it out in a court after taking into account of legal fee and time requirements for a prolonged lawsuit, because American lawsuits tend to be very time-consuming and costly. So sending out an alternate demand letter may start a conversation, but it could also backfire, which I will explain soon. Point 4, you need to anticipate what happens after you send it. Most often, nothing happens. There's no response. They wait to see whether you do anything, especially like large, well-organized insurance companies. Unless you sue them, they will not do anything. Next, most likely, their lawyer will write a simple letter to deny everything, and may even assert some kind of counterclaims or demand on their own. Fourth, the one that you need to watch out for, they may sue you first. So going back to my original point, are you ready? Do you have the resolve and the budget to fight them? A party who receives a clear threat of litigation can often go straight into the court of his own choosing and file for a declaratory judgment, asking for a declaration that he or it does not infringe upon your right or has not breached any contract. You meant to fight on your ground at your own choosing time. Instead, the case is now on his ground at his choosing time. So you need to ask yourself a question. Are you really ready to fight before you send the demand letter, especially a letter with explicit threat to sue them, right? Last, they come to the negotiation table. That may be what you want and usually arrives only after everything above has been weighed, and you should know in advance what kind of offer for settlement you can accept. Fifth point, again, how this may backfire, okay? The obvious cost of sending an attorney demand letter is you have to reveal something, right? Facts and your thinking, what evidence you have, what theories you may be pursuing, roughly. And if you're not careful, you may reveal too many cards. So the danger one with a single letter, the most less than unobvious, if that's an English word, is that with a single letter, you may put in writing the date on which you knew certain facts. Many American claims run not from the date of the wrong being committed, but from the day that the plaintiff discovered the wrong or should have discovered the wrong. For example, security fraud in EB-5 case is the clearest example. The action must be brought before the early of 2 years after you discover the facts constituting fraud, or 5 years after the occurrence of the actual violation. Under Section 13 of the Security Act of 1933, it is 1 year after the plaintiff, the EB-5 investor, discover the fraud, and it's never more than 3 years after the subscription of the EB-5 investment. So a carefully drafted letter, dated, signed by a lawyer with proof of service, may prove something in your favor, but it may also prove your knowledge about something, and your knowledge about security fraud, your knowledge about contract breach triggers the run of the clock of statute of limitation. And if you are not determined to fight, then the alternative demand letter you send out works against you. Your opponent's first defense will not be the merits, but the statute of limitation. And your letter and the date on your letter is their best defense. So, in short, if you're not truly prepared to litigate, you may not want to send a letter with that kind of explicit threat to litigate and with that kind of allegation of security fraud. So the 5 things you need to do before the alternative demand letter goes out. You need to put down your own litigation hold. Okay. Of course, the rule also works in both directions, right? Once you reasonably anticipate litigation, as you threaten the other side with litigation, you also need to preserve the evidence. And then you need to work out the statute of limitation issue with your attorney and get ready to file the lawsuit if the other side does not comply with your demand. You need to figure out how much time is left, and you need to sign a binding engagement letter with your lawyer. Most lawyers in the United States will not send an empty threat demand letter out without being authorized to actually commence the lawsuit. You need to figure out the forum where you actually need to commence the lawsuit. And you need to figure out the backup plan in case if they raise to the courthouse in a forum that may be favorable to them, are you prepared? And you need to work out a number, right? In case they respond with a settlement offer, are you willing to take it? Okay. So a lot of clients will just ask us to draft a demand letter, make it as strong-worded as you can. So we'll sue them if they do not comply. And then say, Lou, how about I pay you $1,000? They are essentially asking us, to try to achieve what a full-blown lawsuit could achieve. And they're only willing to pay us 2 hours of a legal fee. And we usually decline this kind of, bid invitation to work because this is very irresponsible lawyering. A lawyer without investigating all of those statute of limitation forum, understanding the client's legal fee budget and resolve to fight and all that, right? And potential counterclaims and defenses of the other side should not get $2,000 of legal fee and rush into, drafting a alternative demand letter that may backfire. That's not how we practice law. That's not how most responsible lawyers practice law. So do not ask what a demand letter will cost you. Ask your lawyer how much time it will take for you and him to sit down and understand all the facts, all the relevant law, and your other relevant factors like your legal fee budget, like whether you actually have the time to sue the other side, whether you care about your reputation, that you do not want to be engaged in whatever kind of lawsuit that you think you may, be engaged in. So the real question is never whether to send a demand letter or how much your lawyer should charge you. It should require a comprehensive exchange of facts between lawyer and client, and the legal analysis, and also the totality of the circumstance, including the risks involved, before you actually send out a demand letter. Thank you for your attention. This video does not constitute any legal advice to anybody. Part of this video may constitute advertisement for legal service. Thank you.